Good evening, everyone. Welcome. Thank you very much for attending and for hanging on for the finance update, which Andrew Austin and I have put together. And the idea that we've in your pack, you also have a Word document that goes into a bit more detail because we're going to be cantering through the hot topics of the year, which we have identified and listed out here. And we're going to try to talk about the cases which have been published in the last 12 months, which are interesting in relation to these topics. So first up is the age-old problem of non-disclosure. And there are two very interesting cases, Goddard Watts, which is a Court of Appeal authority, and a case called Cummings and Ford, which is not quite as high, but it is from the pen of Mr. Justice Mostyn, and it's characteristically thoroughgoing, so I'm going to address it here. So Goddard Watts, people may have heard of this case, read about it before, because these parties have been engaged in litigation for 13 years. And the finances arising from their marriage have been determined 3 times and are about to be determined for a 4th time. What's the problem? The problem is the husband's non-disclosure, repeated non-disclosure. So the parties reached an agreement which was embodied in a consent order, only for it to then be discovered that the husband had not disclosed the existence of a trust of which he was a beneficiary, which was quite significant. So there was then a contested trial, at the conclusion of which the court made a determination, and it then emerged that the husband had failed to disclose a pending sale of his business, which put an extra £70 million onto the asset schedule, and so that was set aside as well. And the matter came before Sir Jonathan Cohen, and he was persuaded by those acting on behalf of the husband to adopt what has been described as a Kingdon approach. And essentially what that means is that in assessing what to do next, he limited his consideration to the non-disclosed asset. And so he asked himself the question, what does this lady need out of this asset, which we now know exists? He did not ask himself the question, what orders should the court make looking at it in the round? And because the value of the business had grown so significantly, they actually left the wife considerably out of pocket, and so she predictably appealed, and the Court of Appeal agreed with her. And very high in their minds was this idea that sorry if I'm getting a bit close to this microphone, very high in their minds was this idea that the fraudulent non-disclosure among us should not be benefiting from their failure to disclose their assets. And essentially, the message that goes out to those parties who might be engaged in deliberate and intentional non-disclosure is that they can expect to be set aside with a costs order and also be looking at a retrial, which is exactly what's happening in this case. We can look forward to Goddard Watts number 5 or whatever it is, probably within the 12th month. Cummings and Ford is a similar-ish case, but it's interesting because it shows how the same principles can play out on maybe in a slightly more conservative arena. The parties had reached an agreement which the wife then resiled from, and there was a trial. At the trial, it emerged that the husband had not disclosed a £4 million inheritance, which in the context of the case was quite large. And however, at first instance, the judge did not find the non-disclosure of the husband to be, I think the phrase that was used was operative, which is quite unusual because it's not clear where the judge got that phrase from in terms of the rest of the case law. The wife predictably appealed. And she was maybe fortunate that the case came before Mostyn J, and he applied the law that set out very clearly in Goddard Watts and came to exactly the same conclusion, that where the non-disclosure at hand is deliberate and essentially fraudulent, then the court needs to be very careful to be sure that that party doesn't benefit by it, essentially, and that the party deserves to have their whole claim heard again, in full, afresh, de novo, however you want to put it. He also addressed, I think, a theme which comes through loud and clear in practice, which is how non-disclosure can cause all sorts of damage in a case beyond simply the paucity of information. And so in the judgment, the judge talks about how the wife, who was the victim of the non-disclosure, essentially became fixated on the case in a way that she might not have done had that non-disclosure not been a bane of the case. And so again, the message is the wages of this sort of conduct are costs order, set aside, and a retrial. So don't try it, I suppose, is the general message. Moving on to hot topic number 2, that is costs. This is, there's an increasing trend towards considering costs more fully, would be the way I would describe it, in financial remedy proceedings. Making costs orders where parties succeed on their open offer, making costs orders where there are findings of litigation misconduct, but more broadly, considering maybe more carefully than has happened in the past how the costs incurred in proceedings are dealt with in terms of distribution. And we have a couple of cases to look at under this umbrella, the first of which is WC and HC, a decision of Mr. Justice Peel, who is, when one comes at the end of the year to review all the cases that have been published, he's always a prolific publisher of judgments. In this case, both of the parties, in different ways, wanted their costs. The husband wanted his costs because he said, I've been successful at trial, and the wife's open proposal was considerably far away from the determination the court made, so he said I should have my costs. The wife claimed that she had to make interim application for which she should get her costs. They both, as you can see from the slide, racked up quite a lot, frankly, and you'll all be familiar with how high costs are increasingly deprecated by the courts. They frankly had both been slightly inflexible. They had both pursued points which had not been successful in the long run, but the court took the view that the wife was wider of the mark than the husband, and the court very much had in mind this idea that just because a party is a party's case is based on their needs, and that their determination is likely to be based on their needs, that should not mean that they're able to essentially treat the paying party as some sort of insurer in relation to their costs. And so, for that reason, in this case, the wife was ordered to pay $150,000, so not as much as the husband was seeking, but a considerable amount, to be set against her substantial award of $7.4 million. Now, it always there's always a bit of eye rolling in relation to these kinds of cases, and I'm as much in favour of the publication of more ordinary level asset cases as His Honour Judge Hess, who is always asking judges to do it. But it is important to remember here that this was a needs-based award. So the court had come to the conclusion that the wife in this case needed £7.4 million, and so to the extent that she had to pay £150,000 for her husband's costs, that was money that she therefore had to do without. So there is maybe more application than there might appear to be at first blush to your ordinary case. We've then got another interesting case on costs, WC and ZC, another case, another Edward Hess case. The parties had extremely high costs here, and they were roundly told off about it. But essentially, the wife was found in the course of the trial to have spent money in the spirit of vengeance, in relation to the husband's use of prostitutes, which she discovered. If you want to read the judgment, all the sort of details of how she discovered this are in there. And she had spent at a totally disproportionate level. And so His Honour Judge Hess considered how the court ought to approach that. And his conclusions are all set out in the judgment, but essentially where there is a big difference between what one party has spent and what the other party has spent, it's unlikely to be fair to simply take it off the asset schedule as a liability, because that means that one party is subsidising the other. It's a sort of costs order by the back door. He stated that there should be a proportionality assessment running through the entire case in relation to costs, and to try and ensure that costs which are disproportionate to the issues at stake are not run up at all. And what the judge did in this case, and what he says here, that in obvious cases, and absent any proper explanation for the difference between the parties' spending, the court can deal with that unfairness by making an adjustment in the asset schedule before distribution. And that's exactly what he did to the overspending Mrs. C here. He added back £200,000 of her £463,000 spent, which is in context quite a lot. I'm not going, because we're slightly short on time, I'm not going to spend any time on the pensions issue, but this case also has an interesting little vignette, I suppose, on the question of pensions. P&P, this is a decision which was published, it's a decision of Deputy District Judge Hodson, but it was published with essentially endorsement from His Honour Judge Hess, and it concerns a pure sharing case and the treatment of costs. The judgment is entirely focused on the question of costs, because the husband was in person and did not ask for any order related to relating to costs, and the judge simply decided it was fair that he ought to address the question, and so the wife's counsel asked for a written judgment, and that's how this came into being. It's a purely sharing case, but it's not a big money case, so it's actually quite interesting, and this does come up, I would say, quite often, that the parties were both, they were both in their 60s, they had funds which were sufficient to house them, so it wasn't a needs case in the sense of not having sufficient resources. They both had modest independent incomes, and it was agreed that it was a clean break case, and what the judge said was this was always obviously an equal sharing case, and this should have been recognised ages ago. They shouldn't have been spending £150,000 on lawyers, and in fact the judge said it shouldn't even got to Form A, never mind final hearing. And what he essentially said is that the costs owing at the point of the final hearing, even though they were far more on the wife's side than on the husband's side, it was fair to top slice them, to count them as a liability, and therefore have a situation in which the husband essentially was subsidising the wife's spend for a number of reasons. Partly the arguments that he had pursued in litigation, and partly the fact that the wife's solicitors, although they had been very expensive in some respects, they had to do a lot of the running. Hot topic number 3 is one of my favourites, agreements law. It's 13 years since the Supreme Court's decision in Radmacher, and we're still trying to understand it, seemingly, but we have lots of case law coming out every year, including the last year. The first case to have a look at is a decision of Mr. Justice Peel, HD and WB, and this was a situation in which there was an enormous imbalance between the parties. As you will see from the slide, the wife had a huge value of 43.7 million, and the husband had his 63,000 and a very nebulous interest in a business. There was a prenuptial agreement, The court looked at the circumstances, as it's required to do by the authority, and Radmacher looked at the circumstances of the inception of that agreement. And although the husband hadn't taken legal advice, he found that the husband had had the opportunity to take legal advice. And you might recall that the language of the decision in Radmacher from 2010 is all about being aware of the implications of the document which the person is signing up to. And so when that decision came out, I think it was quite widely believed that that meant that you must have had legal advice. But in this case, he hadn't had legal advice, but he could have had legal advice. The judge addressed this, the interpretation of a predicament of real need, which is again language which emerges from the judgment in Radmacher, when it was said that it would be unlikely to be fair for one party to be left in a predicament of real need. And quite what does that mean? Does that mean that that person ought to be saved from destitution, or is it not quite as extreme as that? The court, I'm afraid it answered with, it depends on the circumstances. It declined to say either that it is fending off destitution, or that it is simply a gateway through which, once a party has passed and demonstrated need, they're then opening up the floodgates to a complete and normal consideration of Section 25. But it is useful, and actually there's a recent judgment of Mr. Justice Mostyn in which he's saying something very similar. Agreements. Another case that's very interesting is MN and AN. Now, this is a case that concerns a prenuptial agreement which was signed up to by the parties as long ago as 2005, so it was before the Radmacher decision. And we already have law from the Supreme Court, Rothschild and D'Souza, that tells us just because you signed this document before the Supreme Court gave its decision in Radmacher, that doesn't mean that it's automatically, you're not to be held to it. So that authority was there and essentially underpinned this case. The prenuptial agreement itself in this case is notable because of its terms, in my estimation, because it gave the wife quite a reasonable award, which was based on £500,000 per year of the marriage with a cap and other features. And practitioners might recall back in time that the further back in time you go, the more unreasonable prenuptial agreements generally were. And so it is quite unusual to have a prenuptial agreement from this period of time, which is as generous as it is, and possibly that's one of the reasons that it was upheld. But essentially, the wife failed in two respects. She argued that the award, in accordance with the agreement, didn't meet her needs, and the court disagreed. And she argued also that it was vitiated by undue pressure because she was under the belief that the husband would not have married her if she didn't sign up to the agreement. Threatening not to marry an individual unless they sign up to the agreement, there's plenty of law now that does not vitiate that agreement, although again, that is something which back in 2010, it was very common for practitioners to believe and say. So this is developing law, developing understanding all the time. And that comes to the end of my hot topics, and now I'm going to hand over to Andrew. Thank you for listening.
Good evening. I'm going to be talking to you about child maintenance and conduct, but I'm going to whip through it because it's so late. So there is a big finger at the back. So child maintenance, a big sigh of relief for everybody. The standard CMS form limit isn't changing, so that's fine. This is only dealing with cases that are over about £3,000 per week limit, or £156,000 something now. So what do you do with those incomes over that? Well, the starting point was the Mostyn order, CB and KB, which dealt with the husband, who's a famous member of bass player in a band. He earns in the region of £639,000 a year, and the part of their dispute, they were deciding about child maintenance rates. The wife was proposing £15,000 a year, the husband proposing 7.5. And basically, the judge said, well, both of those figures are plucked out of the air, so not the correct figure. And you see his determination there, which is that the formula not written in marble, but provides a starting point. And then he puts a cap in it, so 156,000 up to 650. You should be using the child maintenance formula. So we then come on to imaginatively titled A Husband versus A Wife. And this was a first instance decision by some Church Vincent. And this is the case where the parties had been married for an incredibly short time, just 2 years. They'd entered into a consent order, which included £20,000 child maintenance and £20,000 child maintenance and £50,000 spousal maintenance. The youngest child at that stage was 8 months. There was very particular provisions for mechanisms of payments, and importantly, the wife received the vast majority of the limited assets, in this case about £700. So the wife then behaved pretty poorly. She moved the children to school without reference to the husband. She made various applications, including an application to varying financial order to accelerate the payment of his capital to a house, and accepted them for each. It was fine. That includes a new global that he does for £72,000 per year, and then dropping £60,000. There was a trade-off as in that reduction, which for these taxes did not require, but there was a quick requirement. She then made a number of applications in the regulation to the Children Act, and the husband made an application for breaching the order, and the wife then applied to vary the financial order yet again. And this application. So the wife, the application sought to rely on the Mostyn formula that we talked about, and that assessment would provide £2,124 per child, rather than £833 per child that he was currently. So in that decision, the judge sent out Section 31 MCA provisions and said it is not correct merely to look at what has changed since the order, as that is just one part of the exercise, the whole circumstances. And then the starting point is that the original order was correct and decided, and therefore if there hasn't been a change of circumstance, the court needs to consider that it's appropriate to exercise the discretion fresh. The Judge Vincent decided against any change. He said that the husband was a high earner and remained so, albeit with a greater income. The wife's circumstances had not changed. She had a home from the previous capital. Because she was now married, notwithstanding that she was married, she didn't contribute to any of her own expenses. The children were at secondary school. She could earn. She decided not to. She rent out her investment property if she chose to. And the children have not changed. Nor did the judge accept the wife's assertion that there'd be a disparity in lifestyle between the husband and the wife because of his increased earnings. And the judge rejected that, saying it's questionable whether it was. She handled it very nicely. Thank you very much. There is then an appeal for Mr. Justice Mostyn J, which is following on from that previous one. There are 3 grounds of the appeal. The only one that's relevant for us for this purpose is that the judge unfortunately failed to follow the approach set down in the leading authorities, that the starting point of child maintenance calculation should be the CLS figure up to 650, of course, the previous terms injected. So in that decision, and it's a very helpful one to read, the court went through the history of the litigation. I shan't do that, but there is a list there, GWRW, M&M, TW, and then KB, CB, and then Collido, Fuchs, and Fuchs. In the end, when it came to this opinion, the judge did accept two major criticisms of the Mostyn formula. That was one, that there had been an unrealistic disparity between what the parent received for one child as opposed to multiple children. The parent earning £650,000 to pay £60,000 for a single child, 40 each for two, and 33 each for three. But he questioned whether a single child does not cost 50% more than each of a pair of children, or 80% more than each of a trio. There are some repetitions. And secondly, that the amount generated by the extension of the formula to incomes up to 650,000 are consistently higher than the levels on what's typically named by the court. And the ones from formula are, he said, unrealistically high and unhelpful at the starting point. So, what is the answer? Well, a terrifying prospect, algebra, my reaction to is actually less economic than it first appears. So it's the adjusted formula methodology giving the child support starting point. So the first step is to find E, which is the income. So we've got, and that's found by, one, identifying the gross income, usually P60 tax returns, reducing it by the number of children, which 11%, 14%, and 16%. Then deducting the amount of pension, and then grossing up these school fees and extras to reflect that they're paid out of net income. So G spells gross, the percentage is 1 minus X, percentages for you math students out there. P is the amount of pensions, and then S is the school fees, and then there's the gross income. So, that's not that difficult. The second step is to then adjust the formula. So first, you need to apply the statutory formula to the first 156,000. And those figures there, 15, 10, and 8,000, are not going to change because they're just the formula. So the second is that you apply the tariff with you apply the necessary tariff, and that's 2.4 for a single child and 3% for each of the 2 and 3 children. And then third, you adjust your shared care. Now, very happily, for all of us, there is a table in both the judgment, and I think it's also in that advance. So what you have to look at is the cohort that you fall into. I haven't put up there the full child support starting point formula, because if you thought the E formula was bad, the other one is terrifying. So don't worry about that. But that's the way. Now, a couple of health warnings. A couple of health warnings is that you cannot use this if there are 4 or more children. If the income is more than 650,000, or if the father, usually I suppose, father's income is unearned, or that he lives off capital. in those cases, you're going to simply be applying the usual Section child support, Section 25 MCA or Schedule 1 provisions. The other matter is that if there's application for variation with the existing child maintenance order, the AFM adjusted formula should not be used. It requires analysis of change, and that when there is an existing one, it's usually manually adjusted for our figure. So, just two other matters before we move on to conduct. Sorry, one other matter before we move on to conduct. The judgment acknowledges that there are anomalies within that formula. The first is on treatment of school fees. A father earning £156,000 and paying £20,000 school fees for two children. His maintenance liability, assessed by Secretary of State, by the CMS, would not take into school fees. And so that would be £10,200 per child. So he would be paying £10,200 times 2 plus £20,000 school fees, so it's 40 grand. Under this formula, so let's say someone earning 157,000, but paying the same school fee for 20,000 two children, he can the formula would come up with maintenance of £18,000 per child. So he would be £8,000 per child. Forgive me. He would be paying 2 lots of 8,000 plus 20,000 for school fees. That's 36,000. So for £1,000, he's going to be paying 4,400 less than the father and CMS, and it's just because of the school fees. And secondly, the other anomaly is that where you have something close to shared care, 175 nights, father who earns 500,000, child maintenance liability is going to be something in the region of 9,700. If he has one extra night, so pure shared care, he falls into a different cohort in the judge's estimations, which would give him a liability of 9,500. So the difference of one extra night is going to cost him 4,400. And the judge answers the criticisms for that those anomalies. He says, basically, tough. It's good enough. It works for most people. That's paragraph 9 of this judgment. He says that where the eyebrows are raised for figures produced by a few cases near the frontier of each cohort, that does not mean that the overall rule is irrational. And you'll see in the judgment that there is some scope for negotiating between the two brackets within tables. That those are not wrong answers. So, a quick gallop through that. Conduct, we've got here a decision by Her Honour Judge Reardon, and that's the interplay between conduct of Section 25G and the Domestic Abuse Act. In this case, it dealt with economic abuse, and the magnetic feature in this case is the husband was illiterate and therefore relying very much on the wife. And it was the wife who was engaged in all sorts of litigation conduct, moving assets, something in the region of about, depending on the figures, 60 to 90,000 from Lansprint. So they set out in the judgment the economic abuse and then the 4 types of conduct situation, the ones that are gross and obvious, meet up by one house to another, the ones that are rare and reflect, and the previous evidence, OG and AG, says that they're only reflected where there is financial consequence that can include economic impression. Secondly, the ad-back jurisprudence, where someone wantonly recklessly spends, litigation of misconduct, and then drawing the evidentiary technique, drawing inferences from of the existence as such in the party's conduct, failing to give full direct disclosure. You can say in this case the judge did find that conduct. And in paragraph 148, she says that the provisions of DAA are quite new, and their role in financial remedy cases is yet to be established. Undoubtedly, not all cases involving economic abuse will have that GAST factor required by Section 55. And the reason this one does, I draw my range of experience of behaviours exhibited by spouses towards each other within their financial relationships. In my view, the feature which has taken this case out of the ordinary, including husband's illiteracy and wife's exploitation of that consequent vulnerability, the deliberate nature of the sexual treated by W, the fact that the behaviour has been sustained for time. Significantly, and this is significant because it's a lower court decision, the judge doubts whether the provision of financial measurability in terms of conduct puts the definition too narrow. She says that, in my view, too narrow interpretation, Section 25G, would render it negatory. It's difficult to imagine a scenario in which consequences which are fully financially measurable are not already taking place into account, either in Section 25A, resources, or B, means. So we take a breath when this is going to open some further discussions. I can get point to this. Then I'm going to skip over SS and RS just because of time. It's a very short version, and I've summarised it in the notes. But the other big case on conduct is Kaidarova and then it's just here. This was a vigorously fought litigation. There had been 11 hearings and they'd spent 3 million on costs. The difference in the parties' position was 5 million and their assets of 48 million. So they're arguing over very little. So he sets out the elements that are required to prove that within the conduct argument, the facts that they meet the threshold, which is high or exceptionally high, or exceptional, and then there's the identifiable and negative financial impact on parties, and there needs to be, of course, to this as well. He then goes on to say that's stage 1, then stage 2. Done that is, the court will go on to consider that pattern misconduct and financial consequences should be matched upon the outcome of the direct remedies. Then he gives a stern warning about recounting the litany of prejudicial comments which do not remotely approach the requisite threshold. If you're drafting a Form E, that is going to be incredibly important for you, as it's going to be doubly important when you get to Section 25 statements, of course, because the court is going to examine those and they're going to be cross-examined. And in fact, we then got some procedural points that the judge is underlined, which are first appointment statements where they go from the court. Firstly, it's always got to be if GOST pleads in the form, or before, if they're during proceedings, you've got to bring those to the court as soon as possible in order for directions to be made. So an application is likely to be required. You have to be confident that they are actually conduct rather than just gripes. And the court, you then have to go through A, B, and C on my third point, setting out what you say the effect is. And then importantly, I think empowering for a first appointment judge is that the court can make orders preventing a party who pleads conduct from relying on it. And that is, I think, going to be a significant relief for a lot of people and lots of litigants who are facing that issue. It's not on there, but there is a warning that the procedural points set out by this justice in this judgment don't necessarily apply when it's just litigation conduct. That can be dealt with in costs, but in all other bits it is. And very lastly, this earlier judgment, it echoes in this one, which is you've got to be careful with what you say. There's no point in simply filling in a statement to a Section 25 statement, Section 25 for 4D with pejorative terms and seek to paint a picture. That is likely now to be punished as houses. So, and very, very lastly, my section is ended, but very lastly, there is a decision, a GA and EL. It's not your practice. It's 2023 at EWFC.
Sorry, can you repeat that?
Yeah, GA and EL, 2023 EWFC 187. It's also a judgment by Mr. Justice Peel. I raise it because a member of Chambers, George Coates, acted for them. It deals with the Daniels and Walker jurisdiction for SJBs. In that case, the Daniels and Walker application was dismissed because it was too late. It jeopardized the trial, and there was no opportunity for the experts to use. So the application for a single expert on one part of the Daniels and Walker jurisdiction leaves. So that then brings us happily to the end. Well, very much.